Good afternoon. Court would again like to express its appreciation for y'all's flexibility. Our next case is State v. Wilkins, and we will hear from the appellant.
Good afternoon. May it please the court, I'm Assistant Appellate Defender Wyatt Orsman, and I represent Mr. Wilkins, the appellant in this case. I'd like to reserve 7 minutes for rebuttal. This case is all about waiver. Neither the Court of Appeals nor the state argue that Mr. Wilkins had a right to a competency hearing under Section 15A-1002 once the trial court made a judicial determination that his competency was in question. Instead, the Court of Appeals held, and the state now argues before this court, that Mr. Wilkins waived that right by not requesting one or by not objecting to the absence of one prior to the conclusion of his trial. Both the Court of Appeals and the state confuse the rules regarding the waiver of rights with the rules regarding issue preservation. But that doesn't really matter because under neither set of rules did Mr. Wilkins waive his right to the competency hearing. The first possibility of waiver is under the waiver doctrine, which defines a waiver as an intentional relinquishment or abandonment of a known right. And since waiver requires intentional conduct, competency is a predicate to waiver. A valid waiver presupposes the mental capacity to act knowingly and intelligently, and indeed that's what this court held in Sides, explaining that a waiver is only valid if the defendant is competent. And grounded in that first principle, the court in Sides went on to hold that it's contradictory to argue that a defendant of questionable competence can waive the right to the very hearing he needs to determine whether the defendant has the capacity to commit waiver. Sides dictates the outcome of this case. The state doesn't dispute that the trial court made a finding that Mr. Wilkins' competency is in question. And once Mr. Wilkins' competency was in doubt, it became impossible to say he knowingly and intelligently waived his right to a competency hearing. Accordingly, under Sides, since Mr. Wilkins could not waive his right to a competency hearing, the trial court erred by not conducting one prior to allowing Mr. Wilkins to be tried, convicted, and sentenced.
So how do we square Sides with Young and Badgett and some of the other cases that say perhaps a little bit differently with regard to waiver?
Well, I think those, so the cases beginning with Young and ending with Badgett fit into two buckets of cases, and both set of cases are distinguishable. In Badgett and King, we have the quintessential failure to preserve, right? Both defendants in Badgett and King said never made a motion in the trial court. So their argument on appeal was the trial court failed to conduct a hearing sua sponte, right? They never made the motion. They never requested a hearing or an evaluation. So there it makes sense to hold that the defendants failed to preserve the issue of the right to, or the argument that the trial court erred by not conducting a competency hearing, because it was never raised at the trial court level.
But was that based on a statutory mandate? Were Young and Badgett based on statutory mandates?
If I remember correctly, Young is the seminal case talking about waiver of a right to a competency hearing. And in that case, Well, Young is from 1977, and so it predates Ash, which is the case where this court articulates the statutory mandate doctrine, if you want to call it, or statutory mandate rule. So it didn't specifically say this is not a statutory mandate, but Young did hold that that the defendant had waived his right in that case. But Young is different. I clump Young and Dollar together. They fit in the second bucket where there was a motion for a competency hearing, and the the trial court did order an evaluation, and that evaluation did occur, and all the evidence that came back from the medical experts said, our medical opinion is that they're competent to stand trial. And so the defendants just chose to forego the hearing because they knew what the answer, they knew what the outcome of that hearing would be. But we have a very different context here, very different facts, right? We have a motion asking for a competency evaluation and hearing. We have a trial court order that says, yes, I find the defendant's competency to be an issue, and I'm going to order a competency evaluation. And then no competency evaluation occurs. There's no development of an evidentiary record. No medical evidence is developed or produced. Right? So whether Mr. Wilkins was competent to stand trial is very much an open question, as opposed to the scenario in Young and Dollar.
But, so I guess my question is your argument more focused on the fact that there was perhaps a violation of a statutory mandate here, or a violation of a trial court order?
I think, yes. It's a violation of a statutory mandate, right? I don't think that this court's holdings in Young and Dollar survive in Ray E.D., right? In Ray E.D. was a 2020 case that arguably for the first time clearly set out what a definition of a statutory mandate is, right? It's statutory language directed at a trial court to do a specific act. Section 15A-1002, subsection B, meets that definition, right? It's specific language directed at the trial court. The trial court shall hold a hearing, right? And a specific act, hold a hearing when the defendant's competency has been questioned. And that's also consistent with other cases that have interpreted Section 15A-1002. This court in Taylor, albeit Taylor was addressing the predecessor statute, but the language is the same, and this court in Taylor said this provision is obviously mandatory. It's obviously mandatory. Section 15A-1002 is a statutory mandate, right? Or else this court has to rewrite ED.
So just to be clear, you're asking us to overturn Young and Dollar?
I think there are other ways this court can resolve this case, but I think if this court decides it wants to confront the issue of whether this is a statutory mandate, the Section 15A-1002, yes. Yes, those cases are not consistent with this court's definition of a statutory mandate, right? It's the same definition this court used in Chandler. It's the same definition this court used in Van.
Do you, just if you'd refresh my recollection, do you argue that in your brief, that we should overturn them?
I argue that Young and Dollar are not consistent with In Re ED. I was not so bold as to say that they should be overturned, because I think there are other ways this court can decide this case. But you know, if this court decides to go the route of deciding this on the statutory mandate grounds, then yes. Like, right, I mean, this court's most recent case law, that's what I remember from law school, right? The most recent cases prevail, right? So if we have a definition of what a statutory mandate is, this statute meets that definition. Anything inconsistent with that doesn't work.
Well, because help me again understand your position correctly. I mean, it seems to me your fundamental problem is that I realize you want to distinguish Young on its facts, but clearly the statutory mandate applied there, correct?
No, the statutory mandate doctrine hadn't been created yet.
No, not the doctrine, but the mandate for a hearing.
Yes.
All right, so it's the same issue here, right? There's a mandate for a hearing. It wasn't complied with, and in Young we said waiver's possible, and so it either can be waived or it can't be waived.
Right. And under this court's most recent case law, in Ray E.D., Chandler, Van, it cannot be waived. Right, that's the definition of a statutory mandate that this court has put out repeatedly since 2020. Right, Young and Dollar
Yeah, what I'm...
don't work.
In case it's not clear, what I'm grappling with is it even really possible for us to rule in your client's favor and leave Young and Dollar intact?
I think this court could distinguish it on factual grounds, the ones that
I'm questioning whether that would be very convincing, ultimately.
I think so. I don't think this court has to distinguish them on factual grounds. I think it can simply say we've held 3 times in the past 4 years, or defined what a statutory mandate is 3 times in the last 4 years. This statute meets that definition. Anything that's inconsistent with that definition has to go.
Or you could argue that there's a carve-out for this particular provision based on our precedent.
Yes, you could, but think about what that means. You have Rule 10, which is the default rule, right? You have to raise it in order to you have to raise it at the trial court level. Get a ruling by the trial court in order for an issue to be preserved. The statutory mandate doctrine says, we've got an exception to that, right? When a statute meets this definition, we've got an exception where the defendant or the appellant doesn't have to raise this issue at the trial court level, right? So that's the exception to the rule. And now, right, if we follow that logic of a carve out, we have an exception to an exception that pulls a statute back into the main channel of Rule 10, all for a statute that is arguably one of the most fundamental statutes in Chapter 15A, right? It protects a defendant who's incompetent from being tried and sentenced.
And
that's wackadoodle.
yeah, well, so I've struggled with that, right? Because you can waive the constitutional competency argument.
No, you can't. No, you can't waive the
Well,
constitutional.
I'm sorry, there are constitutional issues for which waiver is found, right? But this is one where, for whatever reason, the court carved out previously this exception to the competency hearing.
Mm-hmm. Yeah, so I guess I
just
have.
raised that to let you know I struggle with that.
Me too. I've got a 2-part answer. The right not to be tried while incompetent is so fundamental that you can't waive the constitutional right. Section 15A-1001 and 1002 were implemented by the General Assembly to protect that right. It's entirely consistent with the constitutional right that it's designed to protect, that it not be waivable.
But Young has been around since 1977. So if the General Assembly disagreed with this court's waiver, or position on waiver as articulated in Young, it certainly had ample time to revise the statute to reflect that.
I believe it has.
And you think it has?
I believe it has since 1977.
I mean, you think it has overruled Young by statute?
Oh, no, I think it has revised the statute.
Well, yeah, I mean, but it's had ample time to overrule Young essentially by statute, and it has not done that, correct?
No, no, it is not.
So aren't we bound by legislative intent?
I don't think that's a reasonable interpretation or application of that doctrine here, because we also have, right, I mean, conflicting precedent that's defining what a statutory mandate is.
But isn't a question of whether an issue is preserved for appellate review, that's a question of appellate rules of procedure, correct? And isn't it this court's job to decide the rules of procedure, not the legislature?
The last time I heard, yes, it's this, it's this court's.
And isn't this rule fundamentally based on the that is to say, the rule that there's not a waiver here? You started out by explaining that competency is a prerequisite to waive any other rights. And so wouldn't it be completely contradictory to say that if your competency is in question, you can waive your right to a hearing on that?
Yes. Yeah, that's what this court held in Sides, right? Once Mr. Wilkins was found to be, his competency was found to be in question, Sides kicks in. It says, nope, he cannot waive, right? It's illogical to hold that a defendant whose competence has been judicially questioned can waive the right to the very hearing he needs to determine whether he's competent, to the very hearing he needs to determine whether he can even commit waiver. Right, so piggybacking on what Justice, or the lifeline Justice Earls gave me, right, this particular argument is governed by the rules of appellate procedure. This court controls those rules. I think, as this court has said, it looks askance on statutory encroachment on that. So I think it makes sense that the legislature didn't try to overrule Young and Dollar.
Counsel, can I turn your attention to mechanics of the order? So,
Can you give me just a second to grab that?
sure, and it appears at page 12 of the record, pages 12 and 13 specifically.
Yeah, I'm with you.
So in box 6A, the trial court ordered that the sheriff transport the defendant to the local examiner. But your client was released 8 days after the order was entered on bond. Mechanically, how would that provision operate if he was free to walk away, but the sheriff was ordered to take him? Mechanically, I'm not sure how that would work.
Yes, he was not free to walk away. Is the short answer, right? At the time of the hearing, the time this order was entered, he was in the sheriff's custody. So, as the trial court said, the sheriff's office would have to transport him to Butner.
Understand about transportation, but what if your client doesn't surrender himself for transportation? Right, so
But he's already in the sheriff's custody.
But wasn't he released on bail?
Yes, in contravention of the trial court's order saying taking him to Butner.
So despite posting bail, the sheriff should have held him
because there is a valid order entered by a court of competent jurisdiction that says take him to Butner. Right? Sheriff, you take Mr. Wilkins to Butner for an evaluation. Sheriff doesn't do that. Takes him somewhere else and releases him on bond in violation of the trial court's order. Right? And then everything goes south from there. Right? There's no evaluation because the state released him in contravention twice of the trial court's order. Right? Not surprisingly, he didn't travel to Butner himself because he's of questioned competence. There's no surprise that there is no evidence of incompetence in the trial court record because guess what? The state didn't take him to the evaluation where that kind of evidence would have been developed.
But the order just says transport, right? It doesn't say hold and transport.
I don't know how you could transport somebody without holding them.
Well, but, I mean, holding would seem to be a continuous line of custody, whereas transport just means you're hopping in the back of the car and going, or at least that's how I would submit you could read it.
I don't think that's a reasonable interpretation based on the fact that Mr. Wilkins was already in the state's custody at the time the trial court entered the order. I think the order means he's in your custody. While he is in your custody, you'll take him to Butner, and that's not right. That's not what the state did.
So is it your position that once this order is entered, any opportunity for parole, any opportunity for pretrial release disappears? Because I don't know, it seems unrealistic to think that you just carry somebody to Butner. You probably have to make an appointment and be sure that they have beds available or whatever. So is it your position that once the motion was made that any bail should have been revoked?
Yes. Yes, Mr. Wilkins was in the state's custody when the trial court entered the order. The order directed the state to take him to Butner, and they didn't do that. Right? I mean, if the state was so hot to get rid of Mr. Wilkins, why did it enter the safekeeping order? Right? It didn't just release him as soon as it could. It entered another order. Right? So I don't think there's much to be made of the distinction between holding and transporting. I mean, the trial court's order said, at the time the trial court entered the order, he was in the state's custody. Knowing that, the state said, take him to Butner, transport him to Butner. And let's remember, going back to your question, Justice Newby, let's remember what happened in that hearing. There was a motion for a competency evaluation that was uncontested, and in fact, a lot of the evidence or a lot of the allegations came from the jail personnel saying that, hey, we have some real concerns about Mr. Wilkins' competency. We'd like for him to get evaluated. The DA didn't oppose the motion. The trial court granted the motion, finding that Mr. Wilkins' competency was in question. So, given his status as a judicial, however you want to say it, like a judicially determined to be, of questionable competence, I think it's a bad idea to release those people, right, until they have an evaluation.
Well,
Right.
but there's also a box that says defendant shall present himself, right? So, I mean, it contemplates that there are people out walking around who need an evaluation as well. So I.
And that box
I
isn't checked.
Yeah, but I disagree with you a little bit, that the mere fact that an evaluation is ordered means that you're somehow unsafe to leave the jail.
True. But the court didn't check that box in this case, which arguably supports the position that the trial court was not comfortable releasing Mr. Wilkins.
Or it could be that your client was in custody, right? And once he was released from custody, the attorney had an obligation to go to the court and say, hey, circumstances have changed, he can just report.
Oh, yeah, I mean, look, we can dream up all sorts of, like, possibilities, but in this, like, the facts of this case are that he was in custody at the time the trial court released, or entered its order, and it said, take the person who's in your custody to Butner. Right? I don't think it's so far-fetched to say that the state violated the trial court's order by not taking him to Butner. Right? And that's the act that threw a wrench in the mandatory process.
Yeah, and I know you're short on time, and I tend to agree with you that the state needs to dot all the i's and cross all the t's on this, right? And there's an order that says the government has to do a certain thing. But what responsibility does the defense attorney have years on to say, Judge, we had this competency evaluation ordered, never got fulfilled, we need to have it done? It's the same attorney who asked for the initial order.
It's not actually in this case.
It's not, okay.
It's not. He had, I'm blanking on their names, I think Siegley was his attorney at the time of the competency hearing, and then Griffith was his attorney at trial. Right, and I mean, we can speculate about, like, you know, maybe things fell through the cracks or what, you know, whatever, why it wasn't raised, but like, I don't think we even need to go there.
Well, but Siegley was engaging in rejection of pleas and all those sorts of things much further after or much later than the competency evaluation was ordered. And at no point did he say to the court, look, we've got this before we can proceed, we need this order, or need this hearing.
Mm-hmm. Yeah, and I think, I think if you look at this court's discussion in Hux provides the perfect answer to that question. Look at how section 15A-1002 is structured. Anybody can raise the issue. The defendant, defense counsel, prosecutor, the trial court, right? Basically, anybody in the room, we all share in the responsibility of making sure incompetent people don't get tried. Any of them can raise it. But then, right, we've got the state's argument that, hey, even if the prosecutor raises the question of the defendant's competent, the defendant is still responsible for asking for a hearing? Huck says, no, that's crazy. No, the state, well, they don't say crazy. They reject the argument. Right, if the statute doesn't put the burden on the defendant to make the motion, the statute doesn't put the burden on the defendant to object when the hearing doesn't occur. Right, it could have been the trial court that asked for it. It could have been the prosecutor, but somehow the defendant is still on the hook. Huck rejects that argument. I am running short on time. I would love to answer any questions that you have. It'll be better than whatever I say in rebuttal. Okay, thanks.
Thank you, counsel. We'll hear from the appellee.
Good afternoon. and may it please the court. My name is Keith Clayton from the North Carolina Department of Justice, and I represent the state in this matter. I believe in my prepared remarks, I will touch on many, if not all, of the issues just raised, and certainly but I can start anywhere if the court would prefer. How about I start with the automatic preservation argument. Defendant's argument that this matter is, or this issue is automatically preserved is in contrast and in contrary to the prior precedents of this court in Young, Dollar, Badgett, King. This court has never held that the statutory right to a competency hearing under 15A 1002 is automatically preserved if the defendant does not assert that right at trial and should reject the defendant's argument to the contrary. The case law from this court has repeatedly established that the statutory right is waivable if it's not raised in the trial court below. But further scrutiny reveals that defendant's automatic preservation argument is wrong for two additional reasons. First, defendant cannot show here that he was prejudiced by the absence of a statutory hearing as required by this court's prior decisions. Defendant cites In Re E.D., State v. Chandler, which hold that when a trial court acts contrary to a statutory mandate and a defendant is prejudiced thereby, the right to appeal the court's action is automatically preserved. But defendant here has made no showing that he was prejudiced by the absence of a statutory hearing, arguing instead that he need not demonstrate any prejudice from the alleged error. But defendants claim that the statutory right to a competency hearing is not subject to the prejudice analysis under 15A 1443 is wrong. In Flo, a recent decision by this court, in Flo, the court applied the 1443 analysis to an alleged 15A 1002 error. But even if it was error not to conduct the competency hearing in 2018, which the state does not concede, any such error is harmless because, again, there's no prejudice to the defendant here. For one, defendant was fully able to participate in his trial, aid in his defense, and there was no other indicia in the record that defendant might not have been competent to stand trial. And for two, had that 2018 competency determination been made, it would have been stale by the time of trial in 2021. Defendant's assertion that his competency remained in question 3 years after his initial motion fails to acknowledge the rule articulated by this court that the relevant period of time for judging a defendant's competence to stand trial is at the time of trial. That's something this court said recently in State v. Allen and State v. Hollers. And moreover, if a retrospective competency hearing is unreliable after the passage of roughly a year, as referenced in Sides, then logically the state's contention is that a defendant's assertion of incompetency is equally unreliable after the passage of more than a year, and certainly after the passage of 3 years. You know, defendant here has not demonstrated that he was prejudiced by the absence of the hearing in 2018, and he cannot do so. Another reason it's not automatically preserved is that a statute's mandate must be directed to the trial court in order to automatically preserve a statutory violation as an issue for appellate review. A statutory mandate is directed to the trial court when it either requires a specific act by the trial judge or, two, leaves no doubt that the legislature intended to place the responsibility on the judge presiding at the trial or at a specific courtroom proceeding that the trial judge has the authority to direct. Yet here, defendant concedes in his reply brief that completion of the evaluation by a medical professional is actually the triggering event for the court to hold a hearing. So here, just as in Re E.D., because the trial court can't perform the mental health evaluation provided for under 15A 1002B1, the issue is not automatically preserved. Where an evaluation is ordered pursuant to 15A 1002B, there, the provision requires a physician to perform an examination before any specific act is performed by a trial judge. Turning briefly to State v. Hucks, which was mentioned in my friend's argument. Defendant's reliance on State v. Hux is improper, and his reliance on other cases involving the right to counsel in support of this argument, that the statutory right to a competency hearing cannot be waived. But Hux is inapplicable here. This court in Hux explicitly stated that the right to counsel under 7A-450 does not come under the rule articulated in Young and King and Dollar and Badgett that has consistently been applied to waiver of competency hearing cases. So unlike the waiver of counsel issue in Hux, this court has held time and again that the 15A-1002 hearing is subject to ordinary preservation requirements and can be waived. So there's a special rule, if you will, that Hux articulates vis-a-vis right to counsel cases. Turning to the order itself that Justice Berger had asked about, there is no clear evidence in the record as to why defendant was not taken to Central Regional Hospital in the short period of time that he was in custody, but 5 days after the entry of the order requiring the competency evaluation, the trial court entered a separate safekeeping order requiring defendant to be isolated from other inmates due to his aggressive behavior, and that is in the record at page 16. It's unclear why he wasn't taken, but we certainly have this intervening order based on threats and assault of a detention officer.
But you're
that's
not,
also issued.
I'm sorry, you're not suggesting that the intervening order somehow negates or overrides or removes the order for the evaluation, are you?
I'm not suggesting that. I'm simply trying to give factual, and not hypothetical context, but potential factual context for what may have happened here. I'm not suggesting that the other Superior Court order overrules, the previous order or anything of the like. It just sheds light on what may have happened in that brief period of time that defendant was actually in custody. But as noted, defendant was bonded out of jail shortly after his transfer to Central Prison Safekeeping. I think it was 7 or 8 days afterwards. And unlike, I disagree with Mr. Orsbon's argument that the state should have simply ignored the fact that defendant was able to meet the pretrial release conditions and post his bond, that he should have still been retained notwithstanding that, because the state has a mandatory duty to release a defendant whose conditions of pretrial release have been satisfied. The state cited in a notice of supplemental authority the case of State v. Lemieux, a Court of Appeals case, that held specifically that a defendant charged with a non-capital offense must have conditions of pretrial release determined, and then pursuant to 15A-537, once the conditions of release are satisfied, the state must immediately release the defendant. This is mandatory and not optional. So, I disagree, and I disagree with the dissent who argued that, it was the state's fault that defendant was not transported during the brief time that he was in state custody, because again, he was released on bond. He was out for 3 years before his trial, and, he's faulting the state for not doing in less than 2 weeks, something that he didn't do himself in 3 years. But I submit that if the state had declined to release defendant once he posted bond, he would most certainly have argued that that was a violation of his civil rights and his statutory right to mandatory pretrial release, exposing the state to further liability. I'll also turn to State v. Sides for a moment, because I think that's an important issue in this case. Despite defendant's argument to the contrary.
Counsel, before you get there.
Sure.
If you've been in trial courts long enough, you understand that it takes the state and the defendant, the plaintiff and the defendant, jurors, a whole host of individuals to come together and coalesce to get something accomplished in court. And so on the one hand here, we have an order from the trial court directing the government to take a step, right, that the government did not take. And on the other hand, we have a defendant who was bonded out, and then there is no coalescing around resolution, at least with regard to the motion and order for the competency evaluation. How should we treat sort of that friction between the order and the lack of sort of cooperation to get the evaluation done?
Well, as I was mentioning a moment ago, defendant was in the state's custody for a very brief period of time, and we contend that once he was able to make bail and post bond, that we had to release him from custody. And at that point, I think as you noted earlier, the order provides that a defendant may present himself to Central Regional Hospital in this case for examination. The fact that defendant didn't do that, I mean, obviously the state's argument here is that defendant completely abandoned this assertion that he was not competent to stand trial. He abandoned the statutory right that was indeed triggered when the court entered the competency evaluation order back in March of 2018. But after he was released from state custody, he had every opportunity to present himself to Central Regional Hospital for that evaluation. He had, as you noted earlier, there were 2 subsequent pretrial plea hearings during which he did not assert, made no mention of the prior order for evaluation. Notably, in one of those pretrial plea hearings, he did ask for the return of 2 cellular phones. So he was evidently lucid enough to be present of mind to request the return of personal property, yet there was no assertion or any mention of the failure of, the fact that an evaluation had not been done at that point.
But aren't you asking us here to assume that he is competent? Because, I mean, I hear you that the other parties in the system who have the ability to point out that he needs an evaluation didn't. So his counsel didn't, the district attorney didn't, the other judges who came in contact with him didn't in those hearings. But it seems contrary to logic to say that the person whose competency has been called into question by jailers and a DA and the court at some point in time, that he's then competent enough to be held responsible for not himself getting the evaluation, particularly when we know that one of the common features of not being competent is not being in touch with reality and not believing that there's anything wrong with you. I mean, we just know that that's a common feature of a mental illness.
Sure. So I think that's the key distinction between the constitutional due process right and the statutory right, as has been discussed in cases below, and frankly, as is discussed in sides, which I'll elaborate on in a moment. But, well, I'll just say, in sides, contrary to Mr. Orsbon's characterization, the court explicitly declined to address the statutory waiver argument presented in that case. And in fact, acknowledging the continuing viability of Young, King, and Badgett, the court recognized that the state's argument there regarding waiver of the statutory right was consistent with those prior cases and was arguably, quote, correct. To the contrary, in its analysis, sides explicitly stated that the sole question that we must decide is whether there was substantial evidence before the court to trigger the need for a sua sponte competency hearing. And thus, the court's opinion in sides rested entirely on the constitutional due process analysis, which again, where there is substantial evidence before the court that would give rise to a bona fide doubt as to a defendant's competence, indeed that right cannot be waived, and if the defendant doesn't raise it or no one else raises it, the court must raise it sua sponte and conduct a hearing. Here, the defendant, I think importantly, hasn't raised the constitutional due process argument, and indeed, he cannot. I think the failure to raise that argument here is a tacit endorsement that there was not sufficient evidence, substantial evidence before the trial court to raise that claim. I mean, if there were such evidence, I believe we would have heard about it. We would have heard about it either in the briefing before this court from defendant or in the briefing in the Court of Appeals below, and there was no mention of that. And so I think you're right. Where there's substantial evidence that would give rise to a bona fide doubt, I think that presumption is fair. But here, I mean, frankly, defendant raises the issue in 2018 after threatening and assaulting detention officers while he's in pretrial custody in the county jail. And based on that, you know, the very same day as that altercation, for which I believe he was arrested and subsequently convicted, based on that altercation, defendant files an unopposed motion for an evaluation. State doesn't oppose it, judge enters it. But from that point on, okay, the statutory right is triggered, but from that point on, there is no further assertion of that right before trial. And in fact, I mean, to the contrary, there is substantial evidence in the record that the defendant actually was competent to stand trial. And so defendant didn't act in a manner, consistent with a purpose to insist upon a hearing. And what I mean by that specifically is defendant engaged in multiple colloquies with the trial court and expressly stated in his habitual felon plea, hearing that his mind was clear and he fully understood what he was doing. He also spoke clearly and was appropriately responsive during his waiver of testimony colloquy, informing the court that, quote, I made a decision, I thought about it before I made it. There's no other indicia in the record of a lack of competence here. There's no prior mental health history in the record. There's no witness testimony that would call his competency into question. He didn't mount an insanity defense. He took responsibility for his crimes at sentencing. Here, the trial court was able to observe his demeanor, throughout the trial, and in fact noted that defendant carried himself, quote, in a pleasant way.
So along the lines of what I think you're saying, I think a lot of what you're talking about would go to the question of prejudice. And so if we agree that Flo says that violations of the statutory right to a competency hearing are subject to a prejudice analysis, and we think there was no prejudice here, then we don't even have to address whether Young, whether Sides, or whether In re ED overruled Young implicitly, that sort of thing, right? We could resolve the case completely on prejudice grounds.
I believe that is correct, Your Honor. And as you know, those were important factors for this court in Flo. I'll also note that I don't agree that the defendant doesn't have the burden to demonstrate that he is not competent. I don't think that burden is on the state. The state, I think the burden's on the defendant. I think the case law is clear on that.
But it seems here the question is, when there is a reason at some point in time to question the defendant's competency, there's an order that he have an evaluation. And I understand the fact that initially he's in custody, so the order is to the sheriff, and you would contend once he was no longer in custody, the box that should be checked is the one that says he's to present himself. But in a situation, and I also appreciate what you said about the relevant time to assess his competency is at the time of trial. But I guess what I'm curious the state's position on is, what happens to the fact that there was this court order that was not complied with, and how long between, because it seems like we're just saying, well, it goes away if the defendant doesn't raise it again. But what period of time, because I understand that frequently there can be a long period of time between the court ordering a competency hearing and the competency evaluation and the evaluation actually being done. So, how is there any limit here? Like if the, is 6 months, a year, 2 years, at what point are we essentially going to rule that it's okay to no longer put into effect the order that there be an evaluation.
Right. I think, as this court has said numerous times, these cases are very fact-intensive and very fact-specific. So I think as a threshold issue, I don't think it's reasonable to try to lay down a bright line rule in this case. I think, you know, there is case law that says a retrospective competency hearing becomes unreliable after a year. Okay, well, we can use that as sort of a benchmark. But I think there's a couple of things in play here. Here, the defendant completely abandoned his initial argument that he was entitled to a competency hearing. There's no further mention of it at any point. None of the other pretrial hearings during the 3-year period, not before trial, during sentencing, during any of the pleas. It's never mentioned again. And the passage of time, as you noticed, 3 years. However, as I was just discussing with Justice Allen, had there been some other indicia that would potentially give rise that there might possibly have been a doubt as to the defendant's competency, then I think it's sort of a balancing test or a sliding scale, right? So to the extent that there is other evidence that would suggest a potential lack of competency, then maybe the passage of time, a lesser, or even maybe a greater passage of time is offset by the fact that there's still evidence in the record that the defendant may have lacked some measure of competency. And so that factors in to the court's analysis as to whether there was error in failing to pursue and obtain the competency evaluation and then conduct the hearing. I think that's probably the best way I can answer that question right now. But again, you know, here...
But does it go to whether there was error or whether there was prejudice?
Well, I guess that's still more of a prejudice analysis. But if there is prejudice, then of course, you know, arguably, potentially, there's an automatic preservation issue. Arguably, it is error, reversible error, I should say, rather than just error. But maybe if there's prejudice, obviously, it becomes a reversible error. But here, I just want to reiterate, there was not one shred of other evidence in the record other than that initial order entered in March of 2018, before his trial in July of 2021, that the defendant might have even remotely lacked competence. There's just no evidence in the record to that effect. And so, if such a rule is contemplated by this court, I don't think this is the case in which that should give birth to any such rule. Here, the 3 years in the absence of any indicia whatsoever of a lack of competency under the circumstances, it's abandonment. And the case law is clear that a waiver is ordinarily either an intentional relinquishment or an abandonment of a known right or privilege. And that's in the state's brief at citing State v. Harvin. So, we have a lot of cases on intentional relinquishment, not as many, at least in my research, on abandonment. But here, abandonment is certainly part of the waiver analysis, and abandonment is the best way I can describe what has happened in this particular case. Again, I'll just reiterate that because sides completely avoided the statutory analysis, it does not have any bearing on Young, Dollar, Badgett, King. It has no effect on the ongoing viability of those cases, nor does State v. Flo. I think unless there are any further questions at this time, the state would just ask that, this court affirm the Court of Appeals' decision below. Thank you.
Thank you, counsel. Rebuttal.
Thank you. I'd like to briefly address a couple of points by my friend and the questions that were raised here. First, on the issue of prejudice. This court in State v. Probst found an error in not conducting a competency hearing, did not do any prejudice analysis, and ordered a new trial. Flow is distinguishable because in that case, the issue was whether there was a hearing, and the argument was that the procedures used were not adequate. The only case where this court has held that there should have been a hearing and there wasn't, did not do any prejudice analysis. That's State v. Probst. 2, the state tips its hand. On page 17 of its brief, the state acknowledges that Mr. Wilkins asked for a competency evaluation and determination, and that the trial court passed upon that motion. So the state's Rule 10 argument isn't that he didn't bring the motion to the attention of the trial court and failed to get a ruling. It's he didn't ask for the hearing a second time. Thank you.
Thank you.